Let's talk about when the cops mess up, which is never, right? Just kidding. No one's perfect. But let's say that officers obtain evidence illegally. Can they still use it? Nope. That is what we call the exclusionary rule. Think of it as like constitutional karma. So this is based off of a case called Mapp v. Ohio in 1961. I don't know what's up with Ohio during the 1950s, but they kept the Supreme Court busy. And essentially, SCOTUS ruled that evidence from illegal searches cannot be used in court. Why? Because it's illegal. So the exclusionary rule, the sole purpose of it is to prevent police misconduct. Let me tell you about this case. So in this particular situation, officers were looking for a bombing suspect that they believed to live in a halfway house, which is a transitional living center for people that are coming out of prison. Officers show up and they're like, hey, we need to search the place because we think that there's a bombing suspect that lives here. And so this halfway house was run by a woman named Dalry Mapp. She was like, okay, but you're going to need a warrant. And so the officers are like, here's your warrant. Maybe not as dramatic, but essentially they like waved a piece of paper in front of her and she snatched it out. She put it into her bra and then obviously arrest her and they conduct the search. They search high and low. And then essentially what they found were obscene materials, which essentially equated to a pencil sketch of a nude model and like 4 risque books with weird titles like Memories of a Hotel Man. Anyway, Dalry was convicted and sentenced to 7 years in prison. However, her lawyers were like, I don't think so. They appealed the conviction because all of this evidence of the obscene material was obtained illegally. The cops didn't have a legitimate search warrant. That piece of paper wasn't a search warrant. It was a piece of paper. And they tried to convince her that it was a search warrant, but Dalry Mapp was smart. She works with offenders. She knows what's up. She knows what the tea is. She's not putting up with it. So she's going to fight for our rights to not have cops ruin our party. So dumb. So the Supreme Court overrules and basically argues like, no, if officers are going to obtain evidence illegally, it cannot be used against that person. So it's going to get thrown out in court. But wait. It gets better. Enter fruit of the poisonous tree. In this situation, if the tree, such as the original search, is illegal, the fruit is also tainted. So that means that if the original search was illegal, any additional evidence, whether related to the specific crime or any other crime, can now not be used against them because it was also tainted. Let's say that the cops showed up and they waived the search warrant illegally and got the obscene material, but then they also found that Dalry Mapp had like a cocaine problem, which was also illegal. Not the problem, but the cocaine. And they tried to charge her with possession of cocaine. Essentially, not only would the obscene material be inadmissible, also that cocaine is now inadmissible because the obscene material was obtained illegally, and anything from the result of an illegal search also gets thrown out. So other examples, let's say police enter a suspect's home without a warrant or valid exception, and they find stolen jewelry. They arrest the suspect, and during questioning, he admits that he hid the rest of the stolen goods. And then officers go and they recover items and even more incriminating evidence based on that confession. So both the confession and the additional stolen property are fruit of the poisonous tree because they stem directly from an illegal entry into the home. Another example could be an officer stops a driver. The stop itself violates the Fourth Amendment because they didn't have an articulable reason to stop the car. They didn't run a stoplight. They weren't speeding. The cop just pulled them over because they thought it looked suspicious. And as a result of that traffic stop, they see marijuana, a fat stack of marijuana in the back seat or some type of other drug, right? So the officer, plain view, is like, oh, I can seize that and then arrest them. So that evidence would be inadmissible, and like the charges for possession of marijuana or whatever the contraband was are going to be thrown out because the original traffic stop was illegal. The officer did not have an articulable reason to stop the car, and so anything that was found as a result of the search, including the drugs, is tainted and inadmissible. So the tree, which is the stop, was poisoned, so the fruit, the drugs, can't be used. Fortunately, not all is lost because we also have something called the good faith exception. And this essentially means if officers believed that they had a legitimate warrant or they believed that an arrest was legitimate and that resulted in evidence. So as long as officers were acting in good faith, the judge, well, it's obviously up to the judge, but prosecutors can argue, the officer believed that this warrant was still active and have come from an old system. And so the warrant may have been cleared, but just not up in the system. And so all the officer knows at the time is that there's a warrant out for someone's arrest. And so if they find drugs as a result of that arrest, it can still be admissible if the officer was acting in good faith. So if it's an honest mistake, it's usually fine and evidence can still be admissible. But if it's a shady shortcut, toss it. And so the exclusionary rule is the ultimate accountability check, and the sole purpose is to deter police misconduct. And it reminds us that justice can't come from cutting corners, even if you caught someone red-handed.